My name is Joseph Kreps. I'm a DUI defense attorney in the state of Alabama. I want to talk to you today about Alabama Code Section 32-5-171, which is entitled Arrest Without Warrant. And it's in Article 8, which is driving under the influence of intoxicating liquors and or narcotic drugs. It's very important to understand here exactly what this statute says and exactly what it means as we move through this video. It's very important because most people out there are unaware of this statute, and there are a lot of attorneys out there that are unaware of it as well. So it's important that we understand it, that we know that it's there, and that we use it in accident cases, because accident cases are very tough for prosecutors to prove for a number of reasons, and one of the reasons is this statute. A warrantless arrest is per se unreasonable, illegal, unallowed, is not going to pass muster, whatever you want to say. They're not good. A warrantless arrest. And what that means is a police officer generally, if they're going to arrest someone for violation of a statute that is a misdemeanor, not a felony, and a first, second, third DUI in Alabama is a misdemeanor. So if a police officer is going to arrest someone for driving under the influence, they have to actually see that person commit the offense. And in a situation with an accident, it's very rare for the officer to actually see the accident, to see the defendant, our client, sitting in the car. So this statute came about, and it is one of the constitutional exceptions to DUI. And I want you to remember that phrase because it's very important. There are constitutional exceptions to DUI charges and DUI litigation, and it's not right, and it is bothersome, but it's just one of those areas where our rights have been chipped away over time. The statute that we are talking about, 32-5-171, essentially says that a uniformed police officer, state trooper, county sheriff, or his or her deputy, or a member of a municipal police force. Now, that basically covers everyone that could possibly or would possibly make an arrest for a DUI charge. Now, this is the second part of the statute. At the scene of a traffic accident, there are cases out there that talk about what is considered to be at the scene. Is at the hospital considered to be at the scene? Is down the road considered to be at the scene? So it's important that we note, has to be at the scene of a traffic accident. And it says may arrest at the scene any driver of a vehicle involved in the accident. Okay? Any driver of a vehicle involved in the accident, if upon personal investigation, including, not possibly or if available, it says including information from eyewitnesses. Okay? So it has to include information from eyewitnesses. The officer has reasonable grounds to believe that the person, by violating Section 32-5A-191, which is the DUI statute, contributed to the accident. Contributed to the accident, period. The next part of the statute says, he or she may arrest such a person without a warrant, although he or she did not personally see the violation. That's a problem. And the reason it's a problem is because warrantless arrests under the United States Constitution, under the Constitution of the state of Alabama, are per se unreasonable. This is a statute that was passed to get around that. And this statute is on the books. It's been on the books for years. And more than likely it's going to stay on the books. So we just have to know how to operate within the confines of this statute. Think about this. Officer happens up on a wreck 30 minutes after it occurs, 2 hours after it occurs. There's no eyewitnesses. And John, we'll just call our client John, is sitting on a hill with a cooler of beer and is drinking beer, and the car is disabled. How many questions come up about what John was doing? Did John have anything to drink before he was driving? Was John driving? Was John impaired while driving? Where did John get the beer? Was the beer in the trunk? Was the beer in the compartment with John? How many beers has John drank? Did he have anything to drink prior to the accident? Was there another passenger? There are so many questions that generally cannot be answered in an accident case such as this. It doesn't mean that we condone people drinking to the point of impairment and having an accident, and we are trying to shield them from liability, or we are trying to, quote, get them off of their charge. That is not what this is about. This is about a protection that was intended by the founding fathers of this country, that an officer should not be able to arrest someone for a misdemeanor offense that they did not see. So we have this statute. So let's go down through the statute and apply it to John's situation. We'll just assume that this person, that the police officer is proper, that they're a state trooper or a deputy, or they work for a city. Are they at the scene? Well, I would say that they probably are. Okay, they may arrest at the scene any driver if upon personal investigation, okay, personal investigation, including information from eyewitnesses. Now, are there any eyewitnesses? I don't think so. But John would be an eyewitness, is what some prosecutors and some police officers would argue. So let's say that John doesn't say anything, then I don't think that they have the information from eyewitnesses. I don't think that the case goes any further. Let's say that John does talk, and John says, yes, he was driving, but he didn't have anything to drink beforehand. John is probably going to be arrested anyway. Let's just go ahead and put it out there. John will probably be arrested anyway. Well, let's say that John is arrested. Okay? The officer still has to get over the very high hurdle that the officer has reasonable grounds to believe that the person, John, by violating Section 325A-191, contributed to the accident. Cross-examination of the officer. We'll call him Pete. Officer Pete. Did you see the accident? No. Officer Pete. You don't know what caused the accident, do you? No. Officer Pete. You don't know if John had anything to drink prior to the accident, do you? No. You did not see John driving, did you? No. You don't know how much John had to drink after the alleged accident, do you? No. As a matter of fact, you can't tell us beyond a reasonable doubt what caused or contributed to this accident, can you? The answer has to be no, because there's no way that an officer can testify and provide proof beyond a reasonable doubt in that scenario where that would rise to the level of beyond a reasonable doubt when the officer did not see anything, there were no witnesses, there are no eyewitnesses. it just doesn't rise to that level in any case. And those cases need to be litigated. And most attorneys out there, I will tell you, if someone comes in and they have been charged with DUI and there was an accident, the attorney says, oh, they got you. There was an accident, it was a DUI, they got you. And that is wrong. It is not right. Those cases should be litigated. Those cases should be tried if necessary. And the constitutional protection that is out there can still be revived if the attorney goes down through that statute and litigates the case properly. It just makes my blood boil that there are folks out there telling DUI defendants that just because there was an accident, yeah, it may sound bad, it may be bad, but that statute has to be complied with so that the constitutional protections that the statute intended to take away can be brought back if that statute is not complied with. So it's very, very, very important that a thorough examination is done of the facts of the case compared to that statute in order to properly represent someone. Again, it doesn't mean that we condone drinking and driving or that we think that it's okay for people to get out there and have accidents if they're impaired. That's not what we're talking about here. What we're talking about is the criminal process and the fact that a police officer has not seen the violation occur, yet they are going to come out and try to make an arrest based on really nothing. The fact that there was an accident and there's some alcohol, and that's it. And that is not right. That's not the way that the system was set up. It's not a proper charge, and the person in the scenario that I described should have never been charged. If the officer comes out, interviews eyewitnesses, talks to people, goes through the process, can link up with evidence, can link up the fact that no alcohol was consumed from the time of the accident to the time the officer got there, which is very rare. If they can link all those up and put together a solid case, then that case can be litigated, and who knows, the defendant may lose that case. However, it is very, very rare that that situation occurs because those cases are tough for prosecutors to litigate, and it has nothing to do with the prosecutor. It's not that the prosecutor is a bad prosecutor or that the police officer is a bad police officer. It has nothing to do with either one of those things. It has to do with the fact that there are certain protections that we, all of us, enjoy in this country, and if those are taken away and they are gradually chipped away, then we stand to lose all of the freedom that we have. And that is something that I'm very passionate about. So this is a situation and a case type that must be litigated. And it's just not right for someone to tell a DUI defendant that there is no hope, that there's nothing that can be done simply because there was an accident, simply because there was some alcohol involved. It's just not right. My name's Joseph Kreps. I'm a DUI defense attorney in the state of Alabama. And if you have been charged with DUI in this state and there's an accident involved, do not listen to anyone that tells you that nothing can be done because there was an accident, because it may be a sad situation, and because there was alcohol involved. That is not right. It's wrong, and you should not take that advice and go with it. You need to get to a competent DUI defense attorney that can litigate your case for you and can go through the process with you so that you get the best result possible and the best outcome possible as it relates to your DUI charge. You can reach us to begin the conversation about your case at 866-348-2889. I've handled thousands of DUI and related traffic offenses in the state of Alabama, and I can help you. All you have to do is call us or visit our website, alabama DUI-attorney.com. Thank you very much.